results, no appeal. Even the US has actually strengthened dispute settlement in the USMCA and has added new enforcement mechanisms for labor and the environment. And I'll end on this, and I think this is really giving me a lot of hope. The US is currently the main demandeur to have binding arbitration in global tax reforms discussed at the OECD. So the lesson I take away from this is that even the US is not in principle against binding dispute settlement. We've seen evidence in many other fora to the contrary.
Thank you, Joost. Now, Professor Hillman, what are your lessons learned from these last 2 years?
Well, first of all, I want to also thank Kita very much for inviting me to be on this panel, and more importantly, for putting on this panel. I think it's been interesting for me to have attended as much as I could of this public forum and to realize that this is really one of the major events of the entire forum focused on this issue of dispute settlement. So again, a thank you to the Korean International Trade Association for doing it, because I do think it's very important, because I don't really think that I have a whole lot to add to what Joost has just said, because I would completely concur with everything that he said. And I think for me, at least, the most surprising of all was this idea that everyone would appeal into the void. I think when the appellate body ceased to exist, I understood that it would be maybe the United States. And even then, there was a lot of pressure in the United States, don't go down that road. You know, that's a very dangerous road to go down, to appeal into the void. That is, to be avoided. And there was a lot of discussion and maybe even a little bit of hope that the United States would not do that, but they did. Right out of the box, one of the first cases, the US appealed into the void. What was surprising to me is that others followed. And particularly, I would say that the European Union followed. And I think when the European Union did so, it gave room for everyone else in the world to do so as well. So that I would just simply share that. The other impression that I have that's in addition to everything that Joost has just said is my concern that the debate over how to fix the appellate body is starting to simply die away. I think right at the end, there was a lot of discussion, a lot of scholars writing about how we could go about fixing it and what it would take and how to make changes in the system. You had Ambassador Walker coming forward with his set of principles. You had a lot of discussion. You had the then DG, Roberto Azevedo, saying there was going to be this high-level group that was going to remain focused on it. And now, again, you saw just this week, the United States again saying they would not join any consensus to do anything with respect to the appointment or opening up a process, with no fanfare, no discussion, no debate. It's just become very formulaic that at every single meeting, the United States says no, and we move on. And that, I think, is also a little bit surprising to me. I thought there would remain much more engagement in finding a solution. And my concern now is then how and what will motivate the reassessment, a new decision. I think there was, again, hope when the Biden administration came in that, again, the United States would now start to really engage in this process. That, again, has not happened yet. And so my sort of worry and my concern is what is going to be the triggering event that will cause, again, a reexamination, a relooking at the process. But in general, I would completely agree with everything that Joost said in terms of those are the important developments over the last 2 years.
Thank you, Professor Hillman. Now, Professor Ahn, I'll give you the floor in a second to also sort of tell us what, in your view, are the major lessons to be learned from the past 2 years. At the same time, I may ask you to, because here what we're discussing, or we're trying to sort of say, which of these criticisms can actually be resolved. And we've selected a couple of topics together. Let's say that the major strands of criticism that come with respect to the WTO dispute settlement mechanism and how it developed. And one of the first and most often heard, and it's not a recent criticism, is that of the appellate body engaging in gap filling, overreaching. Much has been said about this. For our topic of today, my question to you, Professor Ahn, would be, in your view, is gap filling inevitable? when you have an international agreement such as that of the WTO with its constructive ambiguity, is to a certain extent the role of the judge to complete the agreement and push the negotiators to be more active if they want to. So is it good that the appellate body did what he did, and is it the real problem lies with the negotiating function of the WTO? Is that the problem? And then last but certainly not least, if there is a concern over gap filling and overreach, is that something you can actually correct by making changes to the dispute settlement understanding, by adding another line to say thou shalt not fill gaps? Or is it a question of self-restraint by potentially the new appellate body or the Mpia in the meantime? Professor Ahn, what are your views?
Thank you very much. I'm very glad to see Joost and Jennifer and you in this wonderful session. Well, briefly about the 2-year experience. If you look at the experience of Korean government as kind of just a very normal WTO member, then probably you can recognize the urgency of what we should do. We lost a case recently against Japan, and then we just did the appeal to the void. Although, economically speaking, there is no point for delaying or avoiding the implementation. The mere fact that there is a room for basically nullifying the decision gives the government the incentive to avoid this kind of situation. So we are in the very urgent situation to rectify the problems. Otherwise, even country like Korea is a trading nation, probably that must ensure and cherish the integrity of this WTO dispute settlement system, try to now deviate with this really minimal kind of economic impact. So, and then about your first question about the gap filling issue, of course, in principle, the adjudicators should not fill whatever gaps left by negotiators. In the WTO, it is the exclusive duty of the member to fill numerous gaps and amend and rectify the problems of many parts of the WTO agreement. But in practice, it is often very hard to draw the line between gap filling versus clarification or interpretation. So some degree of stretched interpretation, or you may call it gap filling, seems inevitable. In the WTO, especially after the failure of Doha round negotiation, despite many imminent issues for amending the WTO agreements, the role of adjudicators becomes much more important to sustain increasingly litigious WTO system. However, I believe this is perhaps one of the most important issues the WTO dispute settlement system or the WTO adjudicator should not overstep. Many seem to understand it, inevitable development that the failure of the Doha round negotiation has made the appellate body, for example, engage in overreaching ruling or aggressive legalism. It is true that the appellate body has played a significant role in the difficult time of the WTO, but this situation will only aggravate the stalemate of any future multilateral trade negotiation, since many members will try to resort to gap filling by the dispute settlement system instead of fixing the root problem by concluding the new negotiation. The situation between judge to be more active versus the political negotiators to do their job. Well, I guess it's depending on what we mean by the active here. In case judges do not fill the gap when disputes highlight more problems of the current rules and agreement, the members and negotiators will be more pressured to engage in their roles in fixing the system. In addition, when judges come up with more guidelines or criteria not explicitly enunciated in the treaty text, then members are trying to be more precise and accurate in the negotiated languages to avoid unintended interpretation. This will substantially diminish the room for compromise or constructive ambiguity among members. This is probably what we are observing in the current fisheries subsidy negotiation. So in a way, there is an inverse relationship between legal activism and political activism. But can you prevent this by writing something in the working procedure? I think the problem of overreaching interpretation by judicial body will not be addressed by working procedure or any such rules. It should be handled primarily by self-restraint in practice, but to ensure the integrity of the system and rebuild the trust of the members, the oversight committee suggested for a while by Jennifer actually is a very important idea the WTO member should seriously consider. Let me stop here.
Thank you, Professor Ahn. Very, very interesting. So maybe Jennifer, Professor Hillman, a quick response from your side.
Well, I would only completely agree that I think this issue of whether or not the appellate body has engaged in gap filling and whether or not that is provided for in the rules is one of those key things, because I think of all of the complaints that the United States has rendered against the appellate body, this would clearly be at the top of the list of the genuine concerns. And the problem is manyfold with it. I mean, part of it is, what again, the United States may describe as filling a gap is what another party may describe as a legitimate interpretation of text. And so it ranges in terms of where do you fall on this line of whether or not that was a legitimate interpretation of text and taking the text that's there and moving it where it needs to go in terms of interpreting that versus where it is. Are you making up the law? You're simply writing rules that do not exist. And again, the United States has tried to catalog all the places in which they think literally the rules were written by the appellate body. They just made it up. They added tests into where there's no test in the text. And all of a sudden out comes an appellate body ruling that says you have to do the following 3 things. You have to meet the following 7 criteria. And the United States says, where do you see that in the text? And on the other hand, I would say, the United States' view of what is the point of the WTO text is probably at some disagreement with others. I mean, boiled down to its very essence, the notion that you will hear sometimes from the United States is that anything that is not expressly prohibited in the WTO text must be viewed as permitted. Well, if that's the view you're going to take, you would have a WTO text that would fill this room, because you would have to have every single little thing that could be prohibited actually laid out in the text. So I think that's not sort of, in my sense, a realistic way to look at it. But the other issue that I always come back to is, okay, if you decide that you cannot fill a gap in any way, that you can only interpret the text and that you have to interpret it narrowly, then what comes? What comes when the text doesn't really address the situation before you? And there is where I think there is some room to think about, could there be other options? Obviously, within the text of the WTO agreements is this notion that you send it back to the General Counsel of the WTO and ask them to reach a definitive interpretation. And the problem has been that that's never happened, and is unlikely to happen, and is unlikely to reach a consensus at the WTO General Counsel. So the system that was kind of set up to work on this basically isn't working. Other ideas have been thrown out. If it's an anti-dumping question, send it to the WTO Committee on Anti-Dumping and ask them to try to figure out what would be the right resolution. Again, it's a worthy effort to try. My own concern is, again, I think you're going to run into kind of the same stalemates within each of the relevant committees as you run into. The other idea that you're throwing out is, it should somehow push the political arm of the WTO to get engaged. And maybe that would happen if the WTO appellate body would have simply said, just no, we're not going to reach any ruling, and would have reached that decision early on. I mean, the case gets filed, the appellate body looks at it and says, okay, there is no text on which we can render an opinion. We send it back. We reach no decision at all. Would that have put sufficient political pressure on the system for the members to then come up with a definitive interpretation or something else? I confess I'm skeptical. But again, there's no question that there is always going to be this sense that the appellate body went too far in feeling it had to reach a decision. It had to come up with a solution because otherwise it would be leaving everything in limbo.
Thank you, Jennifer. Now, Joost, I'm interested in your views, given that you're a member, arbitrator of the MPIA, and maybe confronted with sort of some of the jurisprudence and your own task as an arbitrator. How do you view sort of the overreach gap filling argument, and how can it be addressed in the future? Is it a question of self-restraint? Will you show such self-restraint?
No, I do think it's something that is difficult to regulate in rules. It's more an approach, a vision related to the standard of review, how you look at what panels have done. But I think in general, I sense a shared view that perhaps more deference is due to WTO members, to investigating authorities, and in turn more deference by appeal review to what panels have done. Especially if you know that you only have 90 days, 60 days actually. The question to me is, what's the mandate? What kind of review should an appellate instance get into? Is it one of redoing the whole thing or only finding serious errors? And I think it's been much debated, but this idea of not a de novo review, but more of a reasonableness review, and something you see in Article 17.6.2 of the Anti-Dumping Agreement, I find quite interesting. Actually, Thomas Cottier, who is also a member of the MPIA, just published a very interesting piece on this in the Journal of International Economic Law, looking into various standards of review that you could get into. Because if you look at the numbers, in 83% of cases, the appellate body has found mistakes, modified, reversed panels. That is very telling. That is very intrusive. So the question is, can there be a different way of looking at this? And we all know the Vienna Convention. Of course, if you are an adjudicator, you come to one conclusion, you have to. But I think it's fair to say that various adjudicators could come to different conclusions based on a permissible application of the Vienna Convention rules. And perhaps that's something we just have to admit and defer to.
Thank you, Joost. Given that we don't have too much time, I won't add my own comments other than to say that I think what went probably wrong in the appellate body, and I think that is a big difference with some other international courts, take the European Court of Justice, for example, is the appellate body clearly felt it necessary to always add an explanation, to reinterpret the words of the agreement, to provide a definition of public body, identify the 5 criteria that need to be met, and so on and so forth, rather than simply taking the text, applying it to the facts of the case and saying yes or no. I mean, if the less you write, the more you avoid the suggestion that you are indeed rewriting the text of the agreement, and that it stays case specific as it should be. And I guess based on that notion of clarification and predictability, that it's part of its task, I probably took it a bit too far and therefore made itself vulnerable to such criticism. But we'll see what the MPIA makes of it and how the new appellate body, if ever, addresses this criticism. But Joost, you already mentioned the question of standard of review, which was sort of the second topic that I thought would be interesting to discuss here today. To what extent standard of review, actually there's no title in the DSU, standard of review. But there is Article 11 of the DSU, functions of panels, which has been interpreted as being the standard of review. And there's one aspect in particular from the appellate body perspective that has proved to be very problematic, and that's the role that Article 11 of the DSU played in re-examining facts. And one of the major criticisms is that the appellate body, which is supposed to look at errors of law and legal interpretation, has gotten into the re-examination of facts, which has complicated the whole process, which also led to its overstepping its mandate. And in particular, I guess, in the context of trade remedies, we have the additional problem of the panel being already the reviewer of the investigating authority fact finding. Therefore, for sure, in an article, in a context of an anti-dumping or a countervailing duty examination, the appellate body should stay away from the facts. And Article 11 of the DSU cannot be used as sort of the back door to re-examine what panels did. In your view, is this again something we can? Article 11 of the DSU is there. How do we avoid the potential abuse of Article 11 DSU by litigants in the future? In your view, is the fact that Article 11 of the DSU allows potentially for some re-examination of the objective assessment of the panel, is that problematic per se, or is what is problematic the way the appellate body interpreted Article 11 of the DSU and how it seemed to have lowered the standard from hormones to, you know, the egregious errors and the suggestion of bias by a panel, which you would hardly ever find, I suggest, because most, you know, of our panels are actually very serious and objective in their approach to things. But like everyone, potentially make mistakes, but not every mistake should be a violation of their task. How do you, where do you put the criticism, and how can you avoid that going forward with Article 11 of the DSU being part of the DSU? How can you avoid the criticism in the future?
Thank you, Jasper. And of course, we go into the technical weeds of the debate, but I think it's important to highlight that this Article 11 issue illustrates a lot of the criticism that has been floating around, because what happened there is that you have an appellate body who, explicit in the DSU, it says you can only look at legal issues, only legal issues. And yet the appellate body has started to review factual findings. So that could be seen as an example of overreach, the appellate body doing more than legal issues. It gets into the facts. That's the first big picture issue that comes up. The second big picture issue is what I've mentioned earlier. What should be the relationship between the appellate body and the panel? And here you have an example of the appellate body redoing not just the legal findings of the panel, but also sometimes the factual assessments. And of course, if the appellate body starts doing that, and as I said, 83% of cases you reverse the panel, you invite more appeals. And that's why we got at the 68% appeal rate. The last point that I think illustrates the importance of this technical issue: appeal proceedings have been taking more and more time, and appellate body reports have become incredibly long. And much of that has to do with an explosion in Article 11 claims, which they take a lot of time to go through. And they take a lot of time to write up. So Article 11, as technical as it sounds, is incredibly important. I agree with you. Now, there's various ways in which you could look at this. I think one could make a solid legal argument to say Article 11 has nothing to do with standard of review. Article 11, objective assessment of the facts, was not included in the DSU. It was already there in the Tokyo Round Code. It didn't give any mandate to the appellate body because the appellate body wasn't even there. If the drafters wanted the appellate body to review manifest errors of fact, they would have said so. If you look at the CETA, for example, the Investor State Tribunal, there the appellators are given that explicit power. Article 17.6 of the DSU only talks about legal issues, legal interpretations. And in a way, it would make sense. How can you expect an appellate body that gets 60, 90 days to review also factual findings, even though manifest errors? This is supposed to be done by panels. They've taken a year to look into the facts. They have a secretariat. They now have increasingly experienced chairs. You have a review of the descriptive part. You have an interim review. So I think both legally and from a policy perspective, you could argue the appellate body should never, ever get into factual findings. Now, what has happened, and perhaps it's the right, I'm not sure, the right or wrong approach, the appellate body has said, we will look into it, sometimes into factual findings. The challenge there has been that the standard, the test has changed over time, from egregious errors, bad faith, to reasonable, adequate explanation, to even-handedness. So for litigators, it becomes very difficult to know what's going to be the test. So if I would be litigating as a lawyer, you throw it in, you go for it, right? Yet that again may be in an area where the appellate body invented a test. All the tests I've mentioned, they are not written in Article 11. Article 11 says objective assessment. It doesn't say egregious errors or reasoned adequate explanation. Another approach to me could be that actually Article 11 is not the legal issue, the issue of law that the appellate body could look into. At best, perhaps appellators should look at violations of due process, fundamental rules of procedure that have been violated. And that has nothing to do with Article 11. Now, if you look at the past, and I'll end on this, the question is, have there been cases where the appellate body really corrected serious factual mistakes? In other words, is it really necessary for this system of factual review to be set up? Of the 148 appellate body reports, there's been 237 Article 11 factual appeals, 237, so more than one in certain cases. Yet in only 27 cases was the claim upheld, in 20 different cases. Now, I would venture to say that in most or almost all of these cases, the mistake could have been covered by an appeal under the substantive provision, an application of the law to the facts. Or if there was a mistake, the mistake didn't affect the outcome of the case. So I think there's actually not much of a need for an appellator to review factual findings. The panel system works quite well. And again, at best, there may be an exceptional case of due process violations or blatant violations of procedural rules. And perhaps that's where the limit could be set. We'll talk about the MPIA later, but I think what is interesting is that the MPIA text explicitly realizes that Article 11 is an issue. And in the MPIA text, it says, to be able to meet 90 days, the arbitrators may propose exclusion of Article 11 claims. The parties have to agree, but that is one instance where the MPIA is, I think, opening a door for new ideas.
Thank you, Joost. Of course, you could also just say as an MPIA, why not read Article 11 DSU the way you suggest, which is simply the potential of due process violations, but none of the others. And as soon as someone makes an argument that's not a due process violation, I reject it, and I can do that in 2 minutes, basically. But that's maybe something for discussion, one of the questions that I saw coming in as well. Professor Hillman.
Well, thank you. I'm going to only make two quick comments. One is I do think that this whole issue of Article 11 in the standard review is, again, at the heart of why the United States has blocked the appellate body. I mean, the understanding, part of it is, I think the entire dispute settlement system basically did not turn out as the United States expected. And I think that is important to keep in mind that this was actually quite unusual for the United States to sign on to a binding dispute settlement system. You have to remember, this is the United States that refuses the jurisdiction of the International Court of Justice, that is not a member of the Inter-American Court on Human Rights, that is not a member of the International Criminal Court, on and on. The United States basically does not join courts, and yet it agreed to join the WTO and to be bound by its dispute settlement system. But if you look at what was the debate in the Congress of the United States at the time the Uruguay round went through, this issue of the binding dispute settlement system was very much at the core of that debate. And you did see a number of members of Congress basically say, I don't like this dispute settlement system. I am concerned about what it does to the sovereignty of the United States, but I like the agreement on agriculture. I like the agreement on, I like the TRIPS agreement. I like the market access, whatever it is. And therefore I will vote in favor of this. And the response that the United States Trade Representative and others gave to those members of Congress was, don't worry. Don't worry about this dispute settlement system, because, again, in part, the notion is appeals will be very rare. Appeals will be rare. They will be only on narrow questions of law. So do not worry, we are not giving away our sovereignty to this system. And yet, as Joost has just said, 68% of the cases were appealed. That is not rare. And again, appeals would be limited to narrow questions of law. That did not happen. And so a lot of what the United States is now saying is, The reason why we can block, we can do all of this is you, the appellate body, have violated the reasonable expectations that the United States had when it joined the system. You can debate whether that was right or wrong, but there's no question that what was expected and what turned out are very different. And a lot of it is because of this issue of standard review. And then I'm going to put on my hat as somebody who sat here at the appellate body and just say very honestly, as an adjudicator, this is very hard. It is human nature. I mean, it is just human nature to say, well, if I decided that case in the beginning, I would have decided that. If I had had it before me, I would have wanted to emphasize that fact. That is a function of human nature. So the issue is then, how do you honestly tell a judge, no, you cannot just put yourself in the shoes of the original adjudicator. You must look only through the lens of a standard of review. And my sense is, if you're going to do that, I think it needs to be very clear sort of where that level of scrutiny really comes. I mean, is it egregious error? I mean, is that what you're looking for? Because that's a very different kind of a look than was it a well-reasoned decision? I mean, those are really different ways in which an adjudicator might look at it. So I do think going forward, there's going to have to be some serious take on what is the right standard review. And the last comment I will make is, among all of the things that I think was the most difficult for the United States was the fact that the one place in which there actually is a standard of review written into the WTO text in the form of a standard of review, it is in the second sentence of 1762 of the Articles on Anti-Dumping, of the Anti-Dumping Agreement. And yet what happened? The very first case in which Article 1762 is raised, the appellate body effectively reads it out of existence. So for the United States, again, this is extremely problematic that the one place where there is a standard review, that the appellate body literally cuts it out of the agreement and then relies on Article 11 that is not a standard of review in order to effectively do that. So with that, I'm sorry, I've gone on too long on that one. Thank you.
Very, very interesting, Jennifer. Thank you for those comments. And let's see whether the MPIA arbitrators are also have that same human nature, or whether they show the kind of self-restraint that you say is so difficult, apparently. Professor Ahn, maybe a quick comment from your side?
Yeah, just one point. As you know, in the Australia tobacco plain packaging case, the appellant actually submitted a 450-page long submission just about DSU 11 claims. It was huge, but still, the appellate body actually found the violation by the panel. So I think we should pay more attention. I personally think the appellate body is blamed unjustifiably too much. If we ask the question as whether appellate body can intervene into fact-finding, of course they should not. This is clear violation of DSU. But in the Huit-Culluton case, appellate body clarified that whether panel made objective fact-finding, that is a legal question. Actually, panel made any mistake on that will make a critical impact to the success and failure of the whole case. So if you think this question seriously, I think in terms of the integrity of the judicial process, I believe we need more time to address this issue more carefully. Where put the proper demarcation between panel and the appellate body? I think this is a very difficult issue.
Thank you, Professor Ahn. Very interesting comment there as well on the plain packaging case. I won't get into that. What I found interesting there is that the appellate body indeed does find a violation of due process. That sort of one key issue we all seem to agree on is what the appellate body should be looking at if Article 11 of the DSU has a role to play, but then doesn't do anything with it. You know, there's a violation of due process on essential issues of evidence. And the way the panel looked at the evidence or failed to look at it but then doesn't draw any sort of material conclusions from that violation, which I found bizarre, given the amount of time that was spent on these Article 11 of the DSU claims. But that's another matter. Now, maybe we should quickly move on to the third topic of major criticism that we keep hearing about the appellate body, and that's the so-called rule of precedent, the extent to which the appellate body is more keen on ensuring a constant application of its own jurisprudence rather than looking at the text of the agreement. And as a litigator who has appeared before the appellate body many times, I share some of the frustration of those that criticize the appellate body, because many of the questions are really about how do you view this particular case in light of our previous finding in this particular instance. How do you read what we mean by a genuine and substantial relationship of cause and effect? What did we mean when we said genuine and substantial? What kind of questions are those? Where is the text of the agreement? Shouldn't we be talking about that? But the question that I have for my speakers today is it inevitable that if you have a standing appellate body, that you will have, whether you call it guidance or precedent, it doesn't matter that much? A standing appellate body will always be following its own precedent that it set, is that actually something that the appellate body MPIA panels need to respect? Or what should they do with the case law of the last 25 years going forward? We've seen a very recent panel report essentially disagreeing with, disregarding effectively a lot of the case law on safeguards by the appellate body in the recent solar safeguard case. Is that the new trend? Should that be the trend? What are your views? Maybe Professor Hillman, we can start with you.
Well, thank you. I mean, I think part of it is to start with what do we mean by precedent? You know, and in general, I think there's this notion that it really does mean to treat like cases like. I mean, you know, to end up in the same place with respect to what the outcome of a given case. And I have no doubt that when the appellate body first began, I mean, when the WTO's binding dispute settlement first began, this was very important. I mean, I think a key value that came out of those early years was the importance of stability and predictability. That you understood, and again, you had a stable and predictable system. And I think that there was good reason to make that a high value at the very beginning of the system, because I think what it among many other things did is bring a greater degree of legitimacy to the WTO's dispute settlement system. And at some level, it can help sort of boost the effectiveness and the efficiency of the system. And I think you saw that very clearly. Where if you looked at all of the dispute settlement mechanisms in regional trade agreements, in the NAFTA, in other agreements, what you found is a dispute that could have gone to the NAFTA dispute settlement system or other regional dispute settlement systems came to the WTO. And when you asked people why are you all going over to Geneva instead of, you know, doing this case right here when it's a case between the United States and Canada, or, you know, Mexico and Canada, why are you going over to Geneva? Because we understand better how it's going to come out. We can look at all of the precedent. We are more comfortable. We understand how the process is going to work, and we understand what the precedent is going to say to us. So again, I accept that there really was at the beginning a very important value that came out of that reliance on precedent. But I think the balance became very outweighed. I mean, it became very out of balance, where it became almost as though things were written in stone, and the ability to then course correct at all became almost non-existent. It became very formulaic. Is this case like that one? If yes, check the box. Therefore, are there any cogent reasons to depart from the precedent? If not, just here is the answer. And so it became very difficult to do any kind of course corrections, or for the appellate body to be honest about, we got it wrong. We got it wrong. We made a mistake. We need to course correct. Very hard to do as you put so much weight on it. And it's had then a huge implication. I mean, it's had a lot of implications. Obviously, one of them is, if you don't like the precedent, then you become very frustrated that there is no way to get a course correction if you are unhappy with and think the underlying decisions were not good decisions. You don't have any easy mechanism to change. The other thing is, to me, it has created an insiders club. I mean, it means that everybody has to hire Jasper or others because no one else knows all of that precedent. I mean, unless you've read all of these decisions that are now becoming huge in length, it is becoming this very rarefied air in which you can only walk into the room if you can immediately say, well, in DS 347, we said this, and in such and such, we said that. It is creating this notion that no one else, can sort of work within this system. So, I think there was a lot of value that came from it, but the system needed to tone it down and to have a better balance between precedent and the need to sort of course correct, take on anew, have a more honest assessment of whether one case really is sufficiently like another, to be more open to the arguments that where you really should be debating is the text. And as you say, not necessarily spending all of in a hearing debating a phrase that came out of a prior decision. So unfortunately, there wasn't, I think, that course correction that occurred, that needed to have occurred earlier.
Thank you, Jennifer. Professor Ahn, can we have your views on this important topic?
Probably for the sake of time, let me skip.
Good. So then, Joost, over to you. How should one deal with the case law of the past, and do you view precedent really as being problematic, or is it inevitable and maybe a good thing, as Jennifer was saying, if used with moderation, like so many other things in life?
I don't think the situation where the appellate body ended up with was inevitable. I mean, why set up an appeal system? I can see two reasons: correctness and consistency. And I think the negotiators had in mind correctness, to deal with runaway panels that get it wrong. That was a quid pro quo for automatic dispute settlement, to have a safety valve, the appellate body correcting egregious mistakes. The idea of consistency you don't see anywhere in the DSU. I mean, predictability may be related, but I'm not sure that's what they had in mind. And if you think of it, the appellate body decides by divisions of 3, and there's 7. And appellate body members change regularly, yet we've seen a very solid, cohesive set of approaches coming out. I have a paper coming up with Christophe Pelk that tries to look at what we call these 3 C's, which were not written in the DSU, but became practice of the appellate body itself. What do I mean with 3 C's? One is consensus amongst the 3, no dissents, which held for a long time. The second C is collegiality, not in the DSU, in the working procedures. In other words, you'll talk about all 7. Finally, consistency, this very thick practice of precedent. You could say you needed this to set yourself up, but it continued for many years. And one explanation we give to this is that appellate body members were hiding behind numbers, not to be picked out and to be sanctioned in their reappointment procedure, so that you have the 3 C's happening basically to avoid political control in the reappointment process. So my short answer to you is, it is not inevitable that you have that kind of strict practice of precedent.
Thank you, Joost.
Can I only add just really quickly? I forgot to add something, because and it goes to this point that Joost just made, which is the level of precedent. I think in the appellate body you can see as fairly extreme. A paper that was written by Jeffrey Cusick and Sergio Puig, a colleague of Joost and I's, did a very careful sort of data mapping. And just to give you a sense of the numbers, what they found is that in 77% of the cases, the appellate body followed its precedent, cited and followed its precedent. In 10% of the cases, it extended the precedent. So not only did it follow it, but it then went on to create sort of more things based based not on the text, but based on that precedent. In only 6% of the appeals did the appellate body actually distinguish the precedent and say, you know, in other words, it's not really relevant here because these two cases aren't sufficiently like. And in 7% of the cases, it narrowed the precedent that existed. But compared to other appeals courts, this level, 77 plus 10, you know, for the expansion, is an extraordinarily high level of sort of completely following precedent. I mean, that is just not what happens in, at least not in the courts in the United States. And I think not in many, many courts. You would see much more divergence, much more sort of willingness to consider other alternatives than what you saw at the appellate body.
Thank you, Jennifer. Yeah, and I do share Joost's point on consistency. Consistency is a good thing, unless, of course, you're consistently wrong. Then it's less of a good thing. You know, final couple of topics that we wanted to discuss are more looking at the future. Okay, how do we deal with this now? What's next? We know the Mpia is there as a alternative, as a temporary solution. But do we really see it as the solution, or is it close to what Professor Hillman wrote in what I think is a very good paper on the good, the bad, and the ugly, about sort of restoring the confidence in the dispute settlement system? And is it close to an arbitration mechanism that avoids the real issue, which is addressing the criticism that is there in order to restore a functioning two-tier system that works for all members and not just for some? We can also talk about the role, for example, the Secretariat played. Is that where the reform should start, given the, according to some, too important role that the Secretariat plays in writing decisions, in preparing the hearings, and so on and so forth? Or should the reform come through a review mechanism that the membership takes more control of the situation, for example, giving a genuine voice to the membership when adopting a panel or appellate body report, with the potential of sending it back or adding an appendix where there's a disagreement, even if it's not a consensus disagreement, but a disagreement among the membership, so that the appellate body next time the same issue comes up needs to address that. What's the first, or should we start with very technical issues? I think that has been tried, and clearly there's no reaction on the United States side, but is that where the real problem lies? The 90 days rule, Rule 15 on, you know, appellate body members whose mandate ends while being on a case. I don't think that's where the solution lies, but some people have said, look, it's the technical, easy first step that at least gets a discussion going, and then we can deal with the more difficult issues, such as the ones that we addressed today. Maybe, Joost, Professor Pauwelijn, maybe you want to start and sort of give us your views on what's next.
Okay, you had asked me to say a few words on the Mpia, and I should have said so at the beginning of, obviously, I'm not speaking on behalf of the Mpia. I'm here in my personal capacity, but remember, we started off with the numbers on appeals into the void. That is not a tenable situation, right? 11 out of 12 appealed into the void. I do think if members want to have a compulsory dispute settlement system with 2 stages, the solution is there. There's an option there, which is the Mpia. Now, obviously, the numbers are still relatively low. If you look at the number of Mpia participants today, it's 25 members. Now, I like playing around with these numbers because you can count the EU as 28, right? If you count the EU as 28, we reach 52 of 164 WTO members, which is 1/3 of the membership, which is a good beginning in that sense. Now, obviously, major players are not a party to it yet. The US, Japan, Korea. The question is, why is that? Why are they hesitating? I think that the first case will probably come this year, beginning of next year. Many members have a wait and see attitude. Some of them keep believing that the appellate body will be resurrected in the coming months. So with the idea that it's not going to happen, which I think is the reality, may come more of a look at, okay, what's realistically out there. I'm sure some members are in principle against this. The one group that I have real concerns with is some developing countries look at the Mpia as a plurilateral. and they put it in the same box as the joint statement initiatives. I think this is a fundamental misunderstanding. The MPIA is an operation, an arbitration under Article 25 of the DSU. It's a multilateral provision. There's nothing plurilateral going on here. Now, Jasper, and you also asked, what will be the role of the MPIA? Is it just to replicate the appellate body, or is it to start some reform? If you look at the text, it really is a hybrid. Think of it as the platypus of international dispute settlement. The platypus is an egg-laying mammal, right? So it's a mammal in the sense that it's supposed to continue or work as an interim appellate body. Reference is made to the appellate body working procedures, but then it's also potentially laying eggs, right? An egg-laying mammal, because if you look at the text, there's seeds planted in the text to start perhaps something new, to test new ideas. 90 days is reconfirmed, but there's a mandate to set page limits, to set limits in terms of hearings, to also do substantive measures like excluding Article 11. There's an explicit language there that says you only have to look at issues necessary to resolve the dispute, only issues raised by the party, so no obiter dicta. Another thing is it's different people. It's 10 different people, and I can tell you almost all of them have deep experience with panel operations, which I think is crucial. And it makes those people realize we have to defer more to what panels do. There's also, you mentioned secretariat. There is no secretariat helping the MPIA. All of the activity happening now is pro bono without secretariat. Plus, and this is key for members who perhaps want to join the MPIA is a very flexible mechanism because it needs to be implemented case by case. And if you carefully look at for example, on Tuesday, Canada and China submitted an arbitration agreement in the canola case. Small changes are being made in these MPIA agreements. So it's kind of a living mechanism where you can do things, learn from it, adjust. The agreement itself says after 1 year, you should review it. The pool as well needs to be reviewed within 2 years. So newcomers can appoint arbitrators pretty soon. So I sound like a salesman for the MPA, and I don't want to, but I do think, having looked at it now for a while, that it may not be the optimal solution, but there's a solution out there. And I think it deserves a couple of test runs at least.
Thank you, Joost. Now at least I know what the MPIA stands for. It's platypus. They will be happy in Australia. Jennifer, a quick comment. Unfortunately, we're running out of time, so it's like a 1-minute comment, and then we go to Professor Ahn for a closing.
Well, I always regret saying that I don't think anyone should count on the appellate body coming back anytime soon. And so I do think it is important that people look at the MPIA and others. And the other thing that I will say is I don't think we should lose sight of what was the function of this system in the beginning, which was to resolve disputes. It was not to create a body of law or a set of precedents. It was to resolve disputes. And so the question comes, what do you lose if you go through a panel process and then there is an appeal into the void? What you lose is the ability to take that decision to the dispute settlement body, which would help ride herd over compliance. But what you do not lose is a finding that whatever the measure was or was not consistent with your WTO obligations. So to the extent that there is sort of a moral high ground to say it has been adjudicated, you are in violation, come into compliance, that can still happen. And that to me is worth watching, whether it is still worth the process to go through a panel, get a ruling, and then use, if you will, the sort of the right that you are in the right and that the other party is in the wrong and needs to correct their measures, even in the absence of it being formally binding, formally notified, and formally having the dispute settlement body help you in that process. My hope is that that will continue, that panels will continue to exist, and that by and large, parties will come into compliance with the rulings of the panel, even if they were not formally, legally required to do so. I hope.
Thank you, Jennifer. Yes, I share that hope. Professor Ahn, maybe for a last comment. Unfortunately, we don't have much time. Over to you.
Yeah. It is very important to have a good result from the beginning, the initial cases from Mpia. But despite all those merits that Joost explained, we still have a lot of the weakness and drawbacks of the Mpia procedure. So country like Korea, although we really appreciate the importance of the appeal procedure, still they cannot join the Mpia process. So I hope that the current case in line can produce the good result for the membership. In case the appellate body procedure, the rectification is delayed, as Jennifer explained.
Thank you, Professor Ahn. Now, unfortunately, we did receive a couple of questions which I shared with the group. People here, the speakers haven't seen it, and I don't know exactly what will happen, whether we will be cut off in the next minute or so. Yes, people are nodding that that's what's going to happen. So unfortunately, we won't have the time to address these questions. But I'm just quickly going to share a couple of them by way of closing, which is with respect to what Jennifer was saying about the expectations of the United States, and you know, that it thought there were not going to be many appeals. And why is that a legitimate expectation? Was that reasonable of the US to have that expectation? And why was it the first to appeal? Immediately breaking its own expectation, potentially. I think that's a valid question. I also saw a question coming in about what actually is the incentive of the US to restore the dispute settlement mechanism? You know, do we think they have an incentive at the moment? And if so, what would it be? And then a question that was actually addressed to Professor Paul and to Joost about this dilemma between, on the one hand, resolving a dispute, which means interpreting the law, applying the law to the facts, and showing that self-restraint, so that you don't go too far in that interpretation and therefore create new law. And I read the question as being, isn't every application of the law to the facts in fact creating new law or a further clarification of the law? I think very good questions that came in. Unfortunately, we only had 1 hour. I think we'll discuss these questions offline, and I would invite everyone to contact our speakers perhaps directly. I think you have their bios and emails readily available. So thank you very much to my speakers, first of all, to you here in the audience and everyone listening and participating remotely, for attending this session, and we hope you've learned something. I found it very interesting and really sort of fascinating to hear the debate that we had today, and let's hope that debate is continued here at the WTO by the membership as well, because that's obviously what is missing at the moment. Thank you.